All right, so we should be good to go. So thank you all for joining our breakout. Today we're talking about wage and hour issues. The point of this is to be a little bit more informal than the general plenary session. We want to just talk to you about what we're seeing from an emerging wage and hour perspective. So we're not here today to sort of break down what the FLSA is and its history and what does overtime mean, but to talk about more emerging issues in more of a casual way. Okay, so getting started, again, as I mentioned, this is being recorded, so everybody can have the opportunity to review or to share anything that they might have missed after the fact. So today's discussion about wage and hour issues. So why do I like to talk about this? It's because in my experience, the most costly type of exposure an employer has. Wage and hour lawsuits rack up damages in the millions overnight. So it becomes really, really costly when there's a mistake that affects a number of employees. And oftentimes you don't realize it until it's too late. And with these statutes, it's very much like strict liability in the sense of once you make a mistake, nobody cares why or how. There's really no empathy provided. It's just a matter of math. So it becomes a very, very difficult venture. We're dealing with 2 times the wages. So if you have a wage and hour mistake, then the damages are going to be whatever the back wages are that you should have paid the employee. That same amount will be added to that total as liquidated damages, and then attorney fees, which are provided for automatically by the statute. So in some cases, the attorney fees exceed what the individual class members or employees receive because they're automatically awarded, and the attorneys that handle these type of cases usually have hourly rates that are well in excess of $400 an hour. So you can imagine how quickly those cases rack up the attorney fees numbers. Now, the other reason beyond just pure cost, why I think it's important for us to discuss wage and hour issues, is that when the economy becomes a little bit unstable, we see an uptick in litigation. So when employment goes up, litigation goes up, and vice versa. So now we have this sort of up and down situation we're dealing with. We have a number of companies that are changing their compensation plans, that are making classification decisions right now that are going to affect people moving forward. So before you do something now that in 2 or 3 years is going to result in a very costly claim, it's important to make sure that we've looked at all possible pitfalls and identified particularly problematic areas, okay? Also, we're in a pandemic. And so I've seen this firsthand, and I don't blame my clients at all. But a lot of my clients are just trying to keep the doors open. They're trying to keep the lights on. They're trying to make sure that their clients are served, that their employees are safe, that people are understanding the COVID rules, that they're complying with, that slide that we covered during the first general session, all those different rules and regulations, none of which were included the FLSA. So when you're literally putting out fires every single day, the last thing you have time for is to get into the weeds to make sure that you don't have a wage and hour issue. So what we see often is when things like this occur and companies are just overwhelmed, they'll make little teeny changes without thinking much of it, because at the time it seems to be totally consistent with business needs. There's nothing discriminatory about it. There's nothing that raises a red flag. And then again, you're looking 12 months, 2 years down the line, all of a sudden that decision has, from the date it was made now, or in March of 2020, started the time and started damages accruing and accruing and accruing. So now is not the time to get lax on this. So what are we here to do today is to really identify some of these pitfalls and what to do to avoid it, and hopefully avoid it quickly so that you're spending your time on the more important matters in your workplace. So the remote workplace is a topic that I want to send it to Laura to talk about, but we're just going to spend the next few minutes talking specifically about people that are not under our roofs anymore and are now working from God knows where.
Yeah, thanks, Courtney. This has always been a little bit of a sticky issue for employers that have had employees that either request working remotely or the employer finds it favorable to have them working remotely. But now it's going to be, as Courtney said, in the next coming years, a huge issue because everyone's doing it, and a lot of employers never allowed it. And so you may or may not have policies in place. If you do not, I strongly, and I know Courtney would agree, recommend that you put in place a very specific remote work policy outlining how these the reporting issues and what they're allowed to do and not allowed to do. You know, I cover everything from insurance issues, all sorts of things come to mind. But under the Fair Labor Standards Act, as probably everybody knows, you have to compensate your non-exempt employees for any time that the definition is you suffer or permit them to work. So setting aside your exempt employees, you don't have these concerns if it's exempt employees. The concern comes in when you have non-exempt employees working remotely and not following your rules, whether intentional or not. It's, you know, for most of us who work remotely from home, your home life kind of has kind of meshed with your work life now. And so you might have to get kids off to school. So you get up early, work, get the kids off to school, come back and work. And you're not really working those 8 to 5 hours, whatever it is. So a lot of people aren't doing it intentionally, but and may not even want to be compensated for it at this point in time, but you run into a problem when somebody's disgruntled down the line and goes and complains. And then, as Courtney said, it comes back to haunt you. So the Department of Labor will look at, did the employer know or have reason to believe that the employee is working? And the most common issue is work-related emails and phone messages after working hours. So those are the kinds of things that would be used by the Department of Labor and an employee to prove that they worked longer days than their regular work day. It's one of those things that your flag should go up if you regularly get things out of things being messages, phone calls, work-related emails from employees that are outside the regular workday. Your policy should obviously address timekeeping and how these non-exempt employees are supposed to record their time, and it should you know, provide an avenue for people to work non-regular hours. Like you can't set an expectation that you want them to work between 8 and 5, and any work outside of that shouldn't be reported. It should be the opposite. Anytime they're working should be recorded, and when they're not working, it should be recorded. So take an hour off in the morning to get your kids ready and set up for remote school or off to school, and record the hours you worked before that and record the hours you worked after that. But you want very accurate time recording. And if you continually see you know, time records that are inconsistent with the time you're getting emails or phone messages, you need to check that out. So teleworking employees, you have to base their pay on your actual knowledge or your constructive knowledge of when they're working. You're supposed to exercise reasonable diligence. That's not really defined, but again, it should be obvious to you if you're getting messages from people in the middle of the night or very early in the morning or late at night, or emails with work product that appears to have been done outside of what you would expect working hours are. You would be well served to follow up on that. That would be reasonable diligence to explore what's going on. An employer will be deemed to have constructive knowledge if they could have acquired information regarding additional work done through the exercise of reasonable diligence. And so that's what I just referred to. You're going to have constructive knowledge if you're getting those things in the middle of the night and you don't follow up. If you follow up, you can either figure out what they're doing and realize that, okay, they take the whole morning off, so they work, you know, from 10 to 2 in the late night, or they're just working more than they're supposed to be. Employers are not required to cross-reference non-payroll records. So again, this goes to time recording, but you just have to have an eye to people that aren't necessarily correctly recording their time. And certainly you can't instruct them that they shouldn't be recording time outside of the normal work day. So you don't have to look at their phone records to evaluate whether they work beyond their scheduled hours. So you have to use reasonable diligence and you need to document it. So that includes having a reasonable reporting procedure to report unscheduled work hours. So again, even if they're not, just like normal, if you work unauthorized overtime, then you have to pay the employee, but you can discipline them. So you have an avenue, having them reporting their time, make sure they have to report unscheduled time, even if it leads to overtime. And there can be a discussion if they need more time than they are scheduled for to get their work done because they're working remotely. But document your conversations, document your instructions to them, have a policy in writing regarding working time and reporting time. And, you know, by all means, this is the rule, remote or not, but do not discourage or prevent employees from accurately reporting time. That will come back to haunt you. There is no question. You don't have to ask about unscheduled hours if there's a procedure in place. So you have these policies, you tell them how to record it, and you don't have a reason to believe that they're working unscheduled hours. So you put a policy in place, you're not getting emails or phone calls that are at odd hours. So you just assume they're working the way they're supposed to be. You don't have to, you know, that's not notice to you. That's not constructive notice. So you don't have to go out there digging, but if something alerts you, you have to follow up on it. So one of the questions we get is whether employers have to reimburse employees for expenses associated with working from home, including cell phone and internet usage. This is a case-by-case decision, but for the most part, I don't think most employers have to do this or do it. I think many employers just assume that in this day and age, people already have internet in their home and they're probably not paying more for it just because they're using it for work purposes. And the same with a cell phone. Some employers do pay a stipend if employees use their personal cell phone for work, and they did that even when they were in the office. You could consider doing that, but I don't think there's any obligation for the most part to reimburse employees for expenses associated with working from home, unless, and I think we're going to get to that later, but it reduces minimum wage. But I will also note, because it kind of fits into this category, on one of the news programs this week, I'm pretty sure they had a tax expert on it, and for your information and everybody else who's working remotely, the IRS rule is that if you are working from home, but you are a W-2 employee of an employer, so you formally work for an employer, you're not actually self-employed, the fact that you work remote does not give you the right to write off your home office or any of your business expenses. The employer can write off those expenses, and I'm not a tax expert, but for your information, if you are working remotely or your employees are working remotely, they cannot deduct home expenses as business expenses. So that's kind of an interesting thing that falls into that category. Employers are generally obligated to reimburse expenses that are incurred by their employees only to the extent that the expenses would otherwise cut into wages protected under the Fair Labor Standard Act, which basically is minimum wage. If you're in a state other than Michigan, there are different rules, and you should check those out with your attorney in those states. And particularly in Illinois, there are more expansive reimbursement laws held to, and California, but I assume that we probably don't have people from California on this call. The remote workplace solution number 2, audit the expenses that your employees submit to make sure the math is right. So if you are reimbursing expenses, this could be a runaway horse or train wreck if you are not on top of it. So look at whether the item is truly a business expense incurred for the benefit of the employer, and if so, does this cost reduce the employee's earnings below the required minimum wage or overtime rate? So I'm going to use an obnoxious example, but if what if you have an employee who submits their cell phone bill and it's, $200 a month or something, and it turns out that they've got 6 family members on their plan? Well, obviously that whole bill is not a business expense. So you need to get that broken down if you are an employer who is going to reimburse for expenses, to make sure that the things that you're being charged for are only really truly related to that employee's job duties and working from home. And in Michigan, the minimum wage rate is $9.65 an hour. So you need to make sure that if they are responsible for their cell phone bill and it's solely for work purposes, that the cost of that bill doesn't reduce their hourly wage below $9.65 an hour. And also remember, this is the ADA, again, as Claudia pointed out, impacts a lot of these decisions, even though they're not necessarily COVID related. If an employee has to work from home to accommodate their disability, the employer can't require the employee to pay for accommodations that they need or to reimburse them. So if you have I've had ADA cases where they need particular software for poor eyesight or deafness, and the employer has to provide that, and they do it in the workplace. Well, if they have to provide that at home and it's an accommodation to allow them to do their job, then they can't require the employee to pay for it. And that's maybe a bad example, because if they use a computer at home, they might have already had it on their computer, but you get the gist of that. And I think Courtney's going to take over and talk about independent contractors.
Yeah, absolutely. So before I do that, I do just want to give our attendees an opportunity. Anybody have any questions about this remote work situation and any wage and hour implications? Feel free to let me know if you want to do a reaction or put it in the chat or turn your video on. We can handle questions, but just want to make sure that we've covered that and addressed those issues.
Oh, hi, Courtney. It's Lisa Turnbull. I just wanted to clarify. Are we, as the employer, have to pay for those extra, the hearing for the hearing impaired? Now, do we have to pay for it to accommodate them at work, or we don't? I missed that.
Yeah. So if it's for example, they're asking for like a phone improvement so that they can hear on the phone system, then you have to pay for that.
Okay, thanks.
Okay. All right. So independent contractors. This is one that, in my opinion, is most commonly messed up. And it's not because, as some would lead you to believe, employers are here trying to purposefully not pay people and not give them benefits and not give them minimum wage and pay them under the table and all these other things. But in my experience, a lot of companies have used independent contractors to serve certain needs for a number of years. And over time, that sometimes bleeds into a long-term relationship, or it bleeds into them bringing in more independent contractors in different areas. And then they have an independent contractor agreement. And before you know it, they're a workforce of 500 people with 100 independent contractors and 100 1099s going out at the end of the year. That is a really big issue right now. So I will just caution anybody on this call that is using independent contractors regularly, or if you have people that you've used for a number of years, or if you're considering bringing on more independent contractors, be very, 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 very careful. Okay, I can't stress it enough. Right now we have a particular attorney general in the state of Michigan who is focusing on misclassification mistakes. It started even before COVID with unemployment, and then that sort of continued, especially now with employee-specific protections. Okay, so again, independent contractors don't get these protections under the FFCRA, under the Michigan PMLA. So a lot of people that think that's not equitable are trying to take those independent contractors and fit them within the employee box. So please, please, please note that the Biden administration has said that that's going to be a priority of that administration as well. So that's what I wanted to talk about on this slide, which is about what we've seen recently. So in February, we get notice that there's a number of opinion letters that the Department of Labor had issued that the Biden administration is withdrawing. So this is unfortunately what can happen, and it make a difficult life for employers even worse. When we have administration shifts, the new administration comes in, looks at what the old administration did, figures out what they do and do not like, and then will oftentimes try to wash away the things that the old administration did that they think are improper. So we saw this with, Title IX issues. I'm sure everybody was somewhat familiar with that. And now we're getting it with some of the more business-friendly opinion letters that the DOL issued. The Biden administration has started chalking away at those. So we saw 3 go within the last few weeks. One about motor carriers and whether an owner-operator fits within the motor carrier exemption and other employees of motor carriers. So if you are in the transportation industry and you've had certain people that are driving that you've either classified as independent contractors or owner-operators, or that you believe fall within the motor carrier exemption, I would take a good look at that to make sure that you weren't relying on an opinion letter that's now been invalidated. Another one as it relates to distributors of a manufacturer's food products. Again, this gets into trying to figure out who is and who is not an employee, and then a tip pooling opinion letter as well. So I'm not going to spend too much time getting in the weeds on these, but if you have any area that might touch on these 3 opinion letters, you might have got an attorney's letter or an analysis a few months ago saying, oh yeah, we have this great DOL opinion letter that we can rely on if push comes to shove. Now that's gone. Okay, so please make sure that you look at that. Consistent with that theme, on his very first day in office, the Biden administration, by way of Biden's chief of staff, came out and said that they were freezing a number of regulatory opinions. Some of this was misreported. I'm sure some of you have heard the general news reports regarding like prescription drug plan policies and things like that. But what is true is that they froze some of the most recent and notable actions of the Department of Labor, including the final rule that was issued in early January regarding independent contractors. So in early January, under the Trump administration, they provided an analysis that, again, many deemed very business friendly, that really focused on an individual's economic dependence when serving as an independent contractor. So they were creating guideposts for companies to use when trying to ascertain whether they've classified somebody appropriately. That's null and void, okay? So they've froze it, but most people expect it to be totally withdrawn, which means they'll either issue a new final rule or they'll just go under previous guidance and let the courts battle this out. But for now, again, if you saw that final rule in early January and you thought, great, now we have a good argument to make in terms of our independent contractors, you should think again. So the scrutiny is going to come down. The gig economy has been the #1 area that they've scrutinized with Lyft, Uber, a lot of, now we have DoorDash, Grubhub, saying that those employees or those companies not classifying the drivers as employees is a real problem. So they're going to start there and focus on those Silicon Valley, the app-based businesses, and then it's going to trickle down. But in Michigan, again, we have an attorney general, and this is one of her pet projects. So we now have, as Claudia mentioned, an administration with all 3 chambers, a state administration that's focusing on this as well. So you should not have any comfort unless you're really ironclad with your independent contractor analysis. So what I would do for that, when we talk about independent contractors, is make sure that you're looking at Michigan, our UIA, Unemployment Insurance Agency, has good fact sheets regarding the economic factors and the analyses. But there are a number of factors. You can probably find 30 in 10 minutes. The IRS has a 20-factor list. Michigan will rely on that. But they will look at overall, the bottom line is going to be, are you controlling this person and how regular is this relationship? So if I hire a painter to paint my house, I don't really care when that painter is there, so long as it's, during normal hours when my kids are awake. I don't want them coming in at 3 in the morning. I'm not going to tell them how to paint. I'm not going to tell them where to put their tarp. I'm going to expect that they get the job done. I'll pay them for that job. They'll move on. I might see them the next time I need to paint my house. So that's the baseline concept of an independent contractor. Or if I'm here at Plunkett Cooney, we have an IT issue. I'm getting notifications my internet's unstable. I might hire an IT company to come out, do an analysis, give me a report, fix it, and then that's it. They'll move on until the next time I have an IT issue. The problem is when I have somebody who looks very much like an employee, is doing something very similar to other employees, and is here over a continuous period of time, reporting, going to my training sessions, reading my employee handbook. The more of those type of factors you have, the more likely it is that you're going to be hit. And when you're hit for an independent contractor mistake, it's unemployment liability because you haven't been paying unemployment taxes for those people. It's tax liability because you haven't been paying your standard federal and state taxes for those people. And it's FLSA wage and hour liability. Because even if you paid them extremely well, say you're paying your independent contractors $100 an hour, you think they can never make a claim. They still have an overtime claim, okay? So this is, and it seems fundamentally unfair to many, and I've been in cases where I myself have agreed that it's not really the equitable solution. But it doesn't matter how much you pay an independent contractor. If you've misclassified them and haven't paid them overtime, they're going to have an overtime claim on their hands. So don't think like, well, there's no way because, again, I'm so far over minimum wage or so far over what they would be getting if they were an employee that I'm protected. They don't care about what the number is if there's a misclassification mistake. So that's my independent contractor spiel. Very, very similar vein, we have joint employment. Okay, so joint employment is a situation where you have companies that are either vertically or horizontally related. So companies like a corporate parent and then its subsidiaries, or a franchisor and franchisees, or you have two companies that might be contracted together and are engaging each other for various services. Where we see joint employment claims most frequently is with labor contractors, whether that's migrant labor contractors, H-2A labor contractors, temporary staffing companies, but people who are bringing employees from point A to point B, being an employer's premises, to work for a specific period of time. So, for example, there's a lot of joint employment cases in the FLSA realm with migrant workers who have been recruited by labor contractors to come to agricultural companies to stay there for a period of time during their busy season, and then they go back to their home country when all is said and done. So what will happen, unfortunately, for a number of those agricultural employers is that the labor contractors might not live up to their end of the bargain in terms of paying the migrant workers that they recruited and brought over to America. So if the labor contractor doesn't pay the migrant workers and the migrant workers go back home, and the business doesn't realize it because the business has been paying the labor contractor consistently, the business does not have a defense. Because as a joint employer, should that be found, the business is jointly and severally liable for all applicable FLSA violations. So it doesn't matter that the business has already paid that money out once. They might have to pay it out twice to cover the lost wages, the liquidated damages, and the attorney fees. So if you're in a relationship where you're borrowing employees, or you're using labor contractors, or you're using a temporary service agency, you need to look at joint employment factors, which in a lot of ways mirror the independent contractor factors, but it's more so related to how closely are your businesses integrated on a vertical or horizontal level, and how much are you controlling the employees. You need to look at those factors and make sure that you're not unknowingly putting your company in a joint employment situation where you're going to be on the hook for that. The other issue with joint employment is accumulation of hours. Okay, so if you have two companies that are sister companies, and you have me, Courtney Nichols, and I work for ABC company 38 hours a week, and then I'm going over to XYZ company for 10 hours a week to do something different. They're both non-exempt jobs, and they're both ultimately related to the primary business of this conglomerated entity group. You're going to not have to look at just 38 hours and just 10 hours and pay me 38 at my regular rate and 10 at my regular rate. You have to add those two together to get 48, and now I've worked 8 hours of overtime. So that's a real issue for a lot of joint employers, is that they've done separate payrolls, separate timekeeping systems, and they haven't looked to see whether this is a common business enterprise or this is a joint employment situation that's going to trigger having to accumulate those hours and make sure you paid OT. So if you have employees that are bouncing back and forth between companies, even if they're doing different things, even if it's different pay rate, that's not a defense. Okay, the defense would have to be that there's truly not a joint employment situation, and that's a really fact-intensive analysis. Those are the things that you need to be looking for, because the biggest exposure claims that I've seen in the past 10 months don't relate to just common, whoops, I forgot to pay that OT. They relate to independent contractor and joint employment situations where the company didn't realize that they were going to be on the hook for 50, 60, hundreds of employees overtime. because they had them classified incorrectly or they weren't adding the time up together. So that's my joint employment spiel. Now it comes down to while we wait. So this is an interesting topic in terms of, you know, where do we go from here? And I'm going to let Laura try to tell us all what to do now while we're waiting.
Well, one thing you've got to do, I know we are all totally burned out on news, but you've got to stay current with what is going on in Washington, because these, Courtney said, we got a bunch of rules and regulations and opinions that came out in a rush before the prior administration left office. And the first thing the new administration did was pull back some of them and say they're not going into effect. Others they said we're looking at. So honestly, on at least a weekly basis, perusing, you know, the Department of Labor website, or actually signing up for their emails is the easier way to do it. These agencies, a lot of them shoot out emails when changes happen, and you really, you know, you can check in with your lawyers, but the best way to do it is for you to stay on top of what the status is day to day. And if you have independent contractors, like Courtney said, this has been actually, it's been an issue for years, especially in Michigan, going back several administrations, because it's a revenue generator. And so all government agencies want you to classify everyone as an employer. It's just like the Fair Labor, or the Department of Labor wants everyone to be non-exempt. They want all employees to be employees, because then you pay employment taxes, the employee pays employment taxes, and the government has more money. So it's a suspect category. So first of all, see who you're classifying that with. See, like Courtney said, look at relationships with other companies that you might share employees or have some kind of relationship with. And then you really just have to watch the news and stay on top of what's going on. And I highly recommend all the government websites. I just feel like they are wonderfully designed to be very user friendly. And again, they all allow you to sign up for regular emails. And I get that we all get a lot of daily emails that you may or may not want to read, but it would be time well served if you signed up for some Department of Labor news flashes and EEOC, because you will get this information and know, okay, I at least need to call my attorney and ask questions, or read this myself, or follow up with someone, because there could be changes coming that could affect me. It's just changing daily. When we put this together, as Courtney said, there was stuff that didn't make the outline, which was done this week because there are changes. We can't emphasize enough that you can't be confident that rules and changes put in place during the Trump era guidances are going to be carried forward through the new administration. And I would submit, and I think Courtney would agree, that probably most of them, if not all, will not go forward. So we don't really know what to expect, other than don't rely on what's out there. So you still need to know what is coming. Another thing we want to caution you for is watch when you return employees to the workplace. It's pretty widely expected that a lot of people, you know, some people may be remote forever now, but a lot of people will be coming back to change positions because jobs have shifted, duties have shifted, employers have learned how to do more with less. And so when you have exempt employees returning to the workplace, make sure that you're monitoring their job duties, because if their duties have changed enough, they may no longer be exempt. And the example is a store manager that comes back but has, you know, 2 less people per shift in their small retail store. And so now the manager is not strictly managing they're doing way more of the retail aspect of it and way less of the management aspect of it, and that they might not be exempt anymore. And that will come back to bite you, because your managers generally do work overtime. And if you're not paying them as the non-exempt employee and paying overtime, that racks up pretty fast. And those employees also will be the ones to complain about it, because they feel put upon. And at some point, they're going to get tired of the increased job duties without the overtime. They're not going to think it's fair, and you're going to get caught in it.
So just sort of jumping in, I think that's a big one. I think that goes hand in glove with the next question we have. And I got a 5-minute warning from John, so I'm going to try to just touch on these things quickly here. But one of the questions that I've been asked a lot, in addition to people coming back in new capacities, but is reducing everybody across the board. So for example, rather than just take a pay cut, we want our exempt people to work 4 days a week instead of 5, and we'll pay them 80% of their salary. I've been advising against doing that, because that very much looks like you are not paying them a set salary, but instead you're paying them based on hours worked. So if you are reducing salary, commensurate with reducing the expectation of hours worked, you could lose the exemption for that person and every person like that. So when you lose an exemption, it's not an individual mistake. It will relate to everybody in that classification. So all store managers, for example, or all case managers. That's the argument the plaintiff's attorney is going to make, is that you've misclassified them all. So be careful about that, about doing anything that looks like you're not actually paying on an hourly basis, but you're paying on a salary basis. I would also, if you're talking about pay reductions, it's more advantageous to do it across the board at like a percentage. If you're going to do percentages, 5%, without advertising that this is, we want you to work 5% less. We're just, we're asking certain executives to take less because of the uncertain times. Jumping in the same topic with, number 3. So if you have a C-suite and they're telling you, listen, I get what you're telling me about us having people work less in this reduction in pay, but we have to do something. Or you have a C-suite that says, like, I cannot possibly comply with all this FLSA garbage. Okay, I need independent contractors. I need these people to work for multiple companies under my parent. What can you do if you're in human resources or you're running the company and you're trying to tell people, like, I really think this is a problem? At a certain point, you have to just realize you're not going to be able to avoid any and all potential claims while running a successful business. But if you really have concerns about FLSA claims, then I would highly recommend looking at getting an arbitration agreement in place. So arbitration agreements, at least right now, give you an opportunity, if it's drafted correctly, to prohibit people from bringing collective action claims under the FLSA. And plaintiffs' attorneys want nothing more than to bring a collective action claim, because that's a quick way to rack up money and to get their fees. So if you are concerned, then I would have people sign individual arbitration agreements, waiving their right to a collective action and making it go to arbitration. So with that, there's a couple of more questions on here. We're going to take some time and we'll answer these after, and we'll provide an update from Laura and my perspective. We ran over, and we want to make sure to get back into the general session to give everybody an opportunity to ask their questions there as well. But please, if you're sitting here and you're like, listen, these are some of my questions, don't worry. Laura and I are going to do a written FAQ. We'll include it with the final published materials, and we can obviously send that to anybody that might have any questions as well. So with that, you should be getting an invitation to jump back into the main breakout room. We really appreciate the time and you joining us today.